A courtroom is supposed to be the safest place in the justice system. Armed deputies, metal detectors, locked doors, a judge, a jury, every safeguard designed to make sure justice is decided by the law, not by violence. But for these 10 convicted criminals, the courtroom became the last place they would ever see alive. One was shot by a grieving mother. Another was beaten to death by 200 women he'd spent years terrorizing. One swallowed cyanide on live television rather than accept the court's verdict. Every one of them believed they would live long enough to hear justice. They were wrong. These are the true stories of 10 convicts killed during their own trials. Before we begin, tell us where you're watching from. This is Verdict Vault. Number 1. Aku Yadav. Aku Yadav never expected the courtroom to be the place where he would die. After years of escaping justice, another hearing felt like just another formality. Another judge, another set of charges, another chance to walk free. He couldn't have been more wrong. For years, investigators say Yadav terrorized the Kasturba Nagar slum in Nagpur, India. Women accused him of rape, extortion, assault, and murder. Many claimed he attacked victims openly, convinced no one would stop him. Some tried. They went to the police. According to numerous reports, many of those complaints went nowhere. Residents alleged officers accepted bribes or refused to act. Time after time, Yadav was arrested, released on bail, and returned to the same neighborhood where the women who accused him were forced to see him again. With every release, one message became clearer. The law wasn't protecting them, it was protecting him. By August 13, 2004, Yadav was back in court for yet another hearing. Only this time, nearly 200 women filled the courtroom. They weren't there to watch the proceedings. The moment Yadav appeared, the room exploded. Women rushed toward him from every direction. Some had reportedly smuggled small knives beneath their saris. Others threw chili powder into his face, blinding him almost instantly. Then came fists, shoes, and anything else that could be used as a weapon. Court officials tried to intervene. They were overwhelmed. Within minutes, the man who had spent years terrorizing the neighborhood lay dead on the courtroom floor. The attack was over almost as quickly as it had begun. Then came the impossible question: who killed Aku Yadav? Investigators interviewed woman after woman. The answers never changed. No one claimed responsibility. Many said everything happened too quickly to know who struck the fatal blow. Whether that was the complete truth or hundreds of women protecting one another with the same story, investigators were never able to prove otherwise. With no witness willing to identify a single attacker and no evidence isolating one person from the crowd, the case eventually stalled. No one was convicted for Yadav's death. For many outside the courtroom, it looked like mob justice. For many inside Kasturba Nagar, it looked like justice arriving years too late. Number 2. Klaus Grabowski. Every day, Marianne Bachmeier walked into that courtroom. She was forced to look at the man who had murdered her 7-year-old daughter. She wasn't just reliving the crime. She was listening to lawyers ask the court to understand him. Klaus Grabowski was on trial for the kidnapping, sexual assault, and murder of Anna Bachmeier. Under West Germany's legal system at the time, victims' families regularly attended the proceedings, meaning Marianne sat through every hearing, every argument, every attempt to explain the man who had taken her child. The defense described Grabowski as psychologically troubled, a man who needed treatment. To Marianne, he wasn't a patient. He was the reason her daughter was dead. What made it even harder to accept was that Grabowski had already been through the justice system once before. He had previously been convicted of sexually abusing children. Instead of spending decades behind bars, he received psychiatric treatment and was eventually released after authorities concluded he was no longer a danger. Anna Bachmeier paid the price for that decision.
Now, Marianne was expected to trust the very system that had already failed her family once. She couldn't. By the third day of the trial, March 6, 1981, she had already decided how it would end. Weeks earlier, Marianne had legally purchased a Beretta pistol. That morning, she hid it inside her handbag and quietly took her seat inside the courtroom. No one suspected why she was there. As Grabowski stood near the defense table, Marianne reached into her bag. She pulled out the pistol. Then she opened fire. 8 shots echoed through the courtroom. 6 bullets struck Grabowski. Lawyers dove for cover. Court officials froze. Within seconds, the man standing trial for Anna's murder collapsed to the courtroom floor. Paramedics rushed to him. There was nothing they could do. Klaus Grabowski died before the trial could ever reach a verdict. Marianne didn't try to escape. She calmly handed over the weapon and allowed officers to arrest her. Later, surrounded by reporters, she explained her actions with a single statement that would divide an entire nation. "I wanted to kill him." Germany was instantly split. To some, Marianne Bachmeier was a grieving mother who had delivered the justice the courts never could. To others, she had carried out an execution inside a courtroom, crossing a line no society could afford to normalize, no matter how horrific the crime. More than 40 decades later, her actions remain one of the most debated acts of vigilante justice in modern German history. Marianne Bachmeier was sentenced to 6 years in prison. She served approximately 3 years before being released early. She died in 1996 at the age of 46 after battling pancreatic cancer.
Before we continue, thank you to our amazing subscribers for being part of Verdict Vault. If you're new here, take a second to like the video and subscribe. It's completely free and it helps us bring these real stories of justice and truth to even more people. Number 3. Daniel Mark Driver. Ellie Nessler didn't come to court expecting justice anymore. She came carrying a gun. By the time Daniel Mark Driver's case reached a California courtroom in 1993, Ellie had spent years watching the legal system move at a pace she could no longer understand. Driver was accused of molesting at least 4 young boys in Tuolumne County. One of them was Ellie's own son. For Ellie, every hearing felt the same. Another delay, another legal argument, another day spent listening to lawyers debate procedure while the children who had been abused waited for justice. To the court, it was due process. To Ellie, it felt like protection for the man sitting at the defense table. Before coming to court that morning, Ellie borrowed a .25 caliber pistol and hid it beneath her clothing. She walked through the courthouse doors looking like every other concerned parent. No one searched her. No one suspected what she intended to do. Then came her moment. Driver sat at the defense table surrounded by lawyers, focused on the hearing unfolding in front of him. He never saw Ellie approach. She walked up behind him, raised the pistol, and fired. 5 shots echoed through the courtroom. Driver collapsed almost instantly. Court officials and spectators scattered in panic as deputies rushed toward the gunfire. Paramedics were called. Daniel Mark Driver died before his trial could ever reach a verdict. Ellie made no attempt to flee. She surrendered immediately and was taken into custody as stunned parents, attorneys, and court staff tried to process what had just happened. The shooting quickly became national news. For some Americans, Ellie Nessler was a grieving mother who had done what the justice system had failed to do. For others, she had crossed a line that no parent, regardless of the circumstances, could be allowed to cross. The debate reached far beyond California, forcing people to confront an uncomfortable question. When justice moves too slowly, how long before someone decides to replace it? Ellie Nessler was arrested immediately after the shooting and admitted responsibility. A jury convicted her of voluntary manslaughter, rejecting a murder conviction after hearing the circumstances surrounding the abuse of her son. Ellie Nessler was initially sentenced to 10 years in prison.
She served approximately 3 years before the conviction was overturned because of juror misconduct. Rather than retry the case, prosecutors reached a plea agreement that credited the time she had already served, allowing her to remain free.
Number 4. David Paradiso. It started in Stockton, California, with a relationship that had already turned deadly once. Paradiso was accused of murdering his girlfriend. Prosecutors said the killing followed a pattern of escalating control and violence between them, the kind of relationship that ends in tragedy long before it ever reaches a courtroom. By the time he was sitting at the defense table in 2009, the case against him was already building toward what looked like a near-certain conviction. Evidence, testimony, a timeline prosecutors had assembled piece by piece. Paradiso could see exactly where this was heading, and he wasn't interested in sitting through the rest of the process to watch it happen. At some point before that day's session, somehow, past whatever security checks were supposed to catch exactly this, he smuggled a shiv into the room, a homemade blade, small enough to hide in a sleeve or waistband, sharp enough to matter. Nobody in that courtroom had any reason to expect what came next, least of all the man sitting above them all with a gavel, whose only job that day was to keep the proceedings moving toward a verdict. When his moment came, Paradiso didn't go for a witness on the stand. He didn't go for the prosecutor who'd spent weeks building the case against him. He went for the judge, the one person in the room whose entire job was to stay neutral, untouchable, above the fray of accusation and defense. For one genuinely terrifying second, the man meant to preside calmly over Paradiso's fate became the actual target of his violence instead. He never made it. A detective stationed in the courtroom didn't hesitate for even a beat, drew his weapon and fired before Paradiso could close the last few feet of distance to the bench. Paradiso went down almost instantly, the shiv still gripped in his hand, dead within moments of the first shot. The courtroom dissolved into chaos in the seconds after the gunfire, jurors ducking behind their chairs, spectators scrambling for the exits. The trial never reached a verdict. There was nothing left to convict. Paradiso had already decided how his own case would end, just not the way he'd planned it. Authorities reviewed the shooting and determined the detective's use of deadly force was legally justified because Paradiso posed an immediate threat to the judge and everyone else in the courtroom. Because Paradiso died at the scene, the murder case against him ended without a verdict.
Number 5. Sael Angulau. It started years before that courtroom with a Tongan Crips gang, a Salt Lake City street gang federal prosecutors had spent years building a case against, piece by piece, through wiretaps, informants, and a sprawling racketeering investigation. Angulau was one of dozens of defendants swept up in the case, accused of everything from robbery to violent assaults carried out in the gang's name. By 2014, the case had finally reached trial, and prosecutors had a weapon most gang cases never get: cooperators. Former members of Angulau's own crew, people who'd once run beside him, had flipped, trading testimony against their old associates for lighter sentences of their own. That kind of betrayal carries a different weight inside a courtroom than an ordinary witness ever could. It wasn't a stranger about to testify against Angulau that day. It was someone who used to be family, in the only sense the gang understood the word, now sitting on the stand about to help him away. Angulau didn't wait for cross-examination. He didn't wait for his attorney to object. He grabbed a pen off the defense table, the only improvised weapon within reach, and charged straight at the witness stand. A U.S. Marshal stationed in the courtroom opened fire almost immediately. Multiple shots, fired in the span of a few seconds before Angulau ever reached the person he was charging toward. He was pronounced dead soon after, killed with a weapon in a room that was, by design, absolutely full of federal officers specifically trained for exactly this kind of moment. It's the fastest death on this entire list. From the first step of his charge to the final gunshot, barely enough time passed to process what was happening. 1 second, Angulau was seated at the defense table like any other defendant on trial. The next, he was on the floor, and the cooperating witness he'd been charging toward never had to finish testifying that day. Angulau's case is proof that in a federal courtroom, arguably one of the most secure rooms in the entire justice system, the line between on trial and dead can be shorter than anyone watching would ever expect. The shooting sparked a serious debate afterward about use of force policy inside federal courtrooms, whether the marshal had other options, whether a charge with a pen genuinely warranted lethal force, or whether the marshal's split-second read of the danger was exactly the kind of judgment call the job demands. The deputy U.S. Marshal was investigated and officially cleared. The shooting was ruled a justified use of deadly force.
Number 6. Larry Darnell Gordon. Ciali Angilau never made it more than a few steps. Larry Darnell Gordon made it much farther, far enough to leave 2 courthouse officers dead before anyone could stop him. By 2016, Gordon was standing trial inside the Berrien County Courthouse in St. Joseph, Michigan. The charges against him were devastating. Prosecutors accused him of imprisoning, sexually assaulting, and abusing a teenage girl over an extended period, 17 felony counts in total. If convicted, he was facing the very real possibility of spending the rest of his life behind bars. The evidence was mounting. The courtroom wasn't where Gordon believed he would win. It was where he believed he had nothing left to lose. Unlike the defendants you've already seen, Gordon wasn't trying to attack a witness. He wasn't trying to punish a grieving family. He wasn't trying to stop testimony. He wanted out, and he was willing to kill anyone standing between him and the courthouse exit. During a break in the proceedings, courthouse security relaxed for only a moment. For Gordon, that moment was enough. According to investigators, he suddenly attacked a courthouse officer responsible for transporting him. The struggle was immediate. In the chaos, Gordon managed to seize the officer's firearm. Now the balance of power inside the courthouse changed instantly. An armed defendant inside one of the very buildings designed to keep dangerous people under control. What followed wasn't a split-second outburst. It became a violent escape attempt that unfolded through the courthouse corridors. As officers and courthouse employees rushed to stop him, Gordon opened fire. 2 veteran courthouse officers were killed trying to prevent his escape. Others scrambled to protect civilians as panic spread throughout the building. For several terrifying minutes, the courthouse stopped functioning as a place of justice and became an active crime scene. The escape never succeeded. Before Gordon could make it out of the building, bailiffs cornered him. They opened fire. Gordon was shot and killed before reaching the exit. Ordinary people who had come to work expecting another routine day inside a courthouse. Instead, 2 of them never went home. Their deaths sent shockwaves through Michigan's court system. The fallen officers were remembered as experienced courthouse veterans who had spent years protecting others without incident. In the months that followed, Berrien County overhauled its courthouse security procedures. High-risk prisoner transport protocols were strengthened. Additional officers were assigned during inmate movements. Several Michigan counties quietly reviewed and updated their own courthouse security policies, recognizing how quickly a routine hearing could become a deadly escape attempt.
Number 7. Christopher Thomas Vaughn. Larry Darnell Gordon tried to escape before the verdict. Christopher Thomas Vaughn waited until the trial was over, and that made him even more dangerous. By 2021, Vaughn was standing trial inside a courthouse in Roxborough, North Carolina, accused of false imprisonment after prosecutors alleged he had held another person against their will. It wasn't the kind of case attracting national headlines, no television cameras, no packed gallery, just another criminal trial moving steadily toward its conclusion. Jurors listened to the evidence. Attorneys made their final arguments. The judge instructed the jury. Then came the verdict: guilty. Moments later, the judge imposed Vaughn's sentence. For everyone else in the courtroom, the hardest part seemed over. The jury had done its job. The judge had spoken. Bailiffs prepared to escort the newly convicted defendant out of the room. The tension was supposed to be fading. Instead, it exploded. According to investigators, Vaughn suddenly rushed toward the bench just seconds after sentencing. The attack caught everyone off guard. As officers struggled to stop him, Vaughn reached for a bailiff's holstered handgun. For one terrifying moment, he got his hands on it. An armed defendant inside a courthouse that existed specifically to make sure defendants never became armed. Everything happened in seconds. Bailiffs fought to regain control, court personnel scattered, then an officer fired. Vaughn was struck before he could fire the weapon he had taken. The courtroom that had just delivered its verdict was suddenly transformed into an active shooting scene. Unlike Gordon, Vaughn never made it into the hallway. Unlike Paradiso, he never reached the judge. The response was simply faster. His case exposed one of the most dangerous moments in any criminal trial. Because once a defendant realizes there are no more legal victories left to win, desperation can replace reason almost instantly. For courthouse security officers across the country, Vaughn's attack became another reminder that the end of a trial is often the moment requiring the greatest vigilance, not the least. Everyone assumes the danger has passed. Sometimes, that's exactly when it begins.
Number 8. Ganimula Sanjeeva. This case proves something even more unsettling. Sometimes, the danger doesn't come from the person standing trial. It walks through the courthouse front door. By 2025, Ganimula Sanjeeva had become one of Sri Lanka's most notorious alleged underworld figures. Authorities linked him to a violent criminal network and accused him of involvement in 19 murders, making him one of the country's highest-profile defendants. For years, investigators had pursued him through a maze of gang violence, witness testimony, and organized crime investigations. His court appearances attracted enormous public attention. Every hearing came with heightened security, or so everyone believed. On the day of his hearing inside a Colombo courthouse, the atmosphere seemed routine. Judges took the bench. Lawyers arranged their files. Police officers watched the courtroom. The defendant waited inside the dock. To everyone watching, it looked like another ordinary day in a very extraordinary criminal case. Then, one man entered the courtroom. He wasn't trying to force his way inside. He looked exactly like he belonged there. Well-dressed, professional, carrying what appeared to be ordinary legal documents. No one stopped him. No one questioned him. No one realized the attack had already begun. Only when he was standing close to the defendant's dock did everything change. The man suddenly produced a firearm and opened fire directly at Sanjeeva. Gunshots echoed through the courtroom. Judges scrambled for cover. Lawyers fled. Police rushed toward the attacker. Within seconds, Ganimula Sanjeeva was dead. Ironically, the one place specifically designed to keep him alive until justice could run its course became the place where his life ended instead. The investigation that followed exposed one disturbing reality. The assassin had reportedly disguised himself as a lawyer. Rather than fighting through courthouse security, he simply became someone security expected to see. Authorities immediately launched a sweeping review of courthouse protection procedures, trying to understand how an armed gunman had managed to stand only feet away from one of the country's most heavily guarded defendants. Sri Lankan authorities launched a homicide investigation, arrested suspects connected to the assassination, and opened a major review of courthouse security after the gunman allegedly gained access by posing as a lawyer.
Number 9. Slobodan Praljak. His story began decades before he ever stepped inside a courtroom. During the Bosnian War, the former Yugoslavia descended into one of Europe's bloodiest conflicts since World War II. Entire communities were destroyed, civilians were executed, and thousands disappeared as ethnic violence spread across the region. Praljak wasn't an ordinary soldier. He was a senior Bosnian Croat military commander, later accused of playing a leading role in crimes committed against Bosniak civilians during the conflict. The investigation lasted years, so did the trial. Prosecutors presented mountains of evidence, military records, witness testimony, intercepted communications, and accounts from survivors, trying to hold not just one man accountable, but an entire chapter of the war itself. By November 29, 2017, the case had reached its final act. Inside the International Criminal Tribunal for the former Yugoslavia in The Hague, judges prepared to deliver the appeal ruling. The proceedings were being broadcast live around the world. There would be no surprises, only the final confirmation of whether Praljac's conviction would stand. Then the judges spoke. His appeal was rejected. His 20-year prison sentence remained in place. Praljak slowly stood. He wasn't shouting. He wasn't pleading for mercy. His voice was calm, deliberate. "I am not a war criminal. I reject your verdict." For a brief moment, the courtroom fell silent. Then he reached into his pocket, pulled out a small brown bottle, and drank. At first, almost no one understood what they had just witnessed. Court staff looked confused. The judges paused. Then Praljak calmly announced, "I have taken poison." Within seconds, panic replaced silence. Proceedings were suspended immediately. Medical personnel rushed into the courtroom as cameras continued broadcasting the unfolding emergency to viewers across the world. The poison was later confirmed to be potassium cyanide. Despite emergency treatment, Praljak died in a nearby hospital later that day. Unlike every other defendant on this list, no officer fired a weapon, no one attacked him, no one pulled a trigger. The final decision belonged entirely to him. Perhaps the most disturbing question came afterward. How had a convicted war criminal managed to carry cyanide into one of the most secure international courtrooms in the world? The answer exposed serious security failures. Dutch authorities launched an immediate criminal investigation. Tribunal officials reviewed screening procedures, prisoner transport protocols, and courtroom security, trying to determine how a bottle of deadly poison had passed through layers of protection specifically designed to prevent exactly this kind of incident. For millions watching live television, the verdict itself quickly became secondary. What they remembered was the 12 seconds that followed it.
Number 10. Michael James Marin. By 2012, Marin was standing trial in Phoenix, Arizona. To the jury, the case wasn't about murder, it was about money. Prosecutors accused the former investment banker of orchestrating an elaborate insurance fraud after his multi-million-dollar mansion burned to the ground. According to investigators, the fire wasn't an accident. They alleged Marin had deliberately set his own home ablaze, then escaped through a rope he had prepared beforehand, hoping to collect millions of dollars in insurance proceeds. For weeks, jurors listened as prosecutors dismantled his story piece by piece. Fire investigators, financial records, expert testimony. Each day, the case moved a little closer toward the same conclusion. Marin rarely showed emotion. He didn't lash out, he didn't argue with the judge. He simply sat through the proceedings, almost as though he already knew how they would end. Then, the jury returned. Guilty. There was no outburst, no shouting, no desperate attempt to attack anyone inside the courtroom. Instead, Marin calmly reached into his jacket, pulled out a small capsule, and swallowed it. At first, almost nobody reacted. It looked like an ordinary pill. Then, within moments, Marin began showing signs of severe distress. The courtroom froze. Jurors looked on in disbelief. Attorneys rushed from their seats. Medical personnel were called as deputies cleared the room. Despite emergency treatment, Marin collapsed. He was transported to a nearby hospital where he died a short time later. The medical examiner later determined the capsule contained cyanide. Just like Praljak, Marin had entered the courtroom already carrying his own escape plan. The guilty verdict hadn't changed his mind. It had simply triggered a decision he had almost certainly made long before the jury filed back into the room. His death left investigators asking the same uncomfortable question that followed the Praljak case. 10 defendants, 10 courtrooms, 10 deaths. Some believed they could escape justice. Some believed they could outrun a guilty verdict.
Others believed the courtroom itself would protect them. If this video changed the way you think about courtroom security or about how quickly justice can spiral into chaos, let us know in the comments below. And if you enjoy deeply researched true crime documentaries built from real court records and verified cases, subscribe to Verdict Vault and turn on notifications, because sometimes the most unbelievable crimes happen in the one place they were never supposed to happen at all.